Hello, London. Hello, England. Hello, world. I was going to put my lawyer's hat on today. I'm not currently a practicing lawyer, and this is not legal advice. I'm putting a lawyer's hat on. I wanted to talk about defendants using social media before trials. Now, of course, I'm not going to mention any cause celebres, either past or upcoming. How's the angle? However, when I was at law school X years ago in the 2000s, this issue just did not exist. As a general rule and principale, individuals, whether in the media or themselves, were not allowed to talk and are not allowed to talk about upcoming trials, sub judice. So 20 years ago, this sub judice rule obviously only applied to the printed press or newspapers online and so forth, because they were the only individuals who were able to transmute that information. By the way, comment below, like, and subscribe. Subscriptions to this channel are very low. It's been going for almost 3 weeks. Views are good, as in they're at good levels, but subscribe, please. Right, so 20 years ago, the sub judice rule obviously applied to defendants and complainants, alleged victims, alleged perpetrators, and the press. But the only individuals who could transmute this information were the press, because an individual defendant could not get his or her story out to the world without the press. Go back another decade, 30 years ago, completely impossible. Now, with the advent of smartphones, defendants are able to talk online. They're allowed to chat. Yeah, chat, not GPT. So, how are the courts dealing with this? I think partly this is to do with the information highway and the fact that there is so much information out there and available. So, defendants talking online, whether or not they're celebrities, not mentioning any celebrity cases, either past, present, or future, I know better than that, or anonymous individuals have got their TikTok accounts, they've got TikTok, Facebook, maybe Snapchat stories, X, and many of them may ill-advisedly talk online. What's the effects of this? Well, the whole principle of something being sub judice is that you can't have information out there that will affect the jury, that will impair or hamper or prejudice the jury. Now, obviously, if there is a famous defendant, the jury already know about him or her, their backstory, might have seen him or her in concert, read his or her books, listened to his or her music or so forth. The most infamous trial of the past 50 years, I'd say the O.J. Simpson trial, or even the Michael Jackson trial 20 years ago, in neither of those instances did the individuals put anything on social media because social media didn't exist. Even in '05, there was no possible way for the defendants to put their public pronouncements out there. Interestingly, Michael Jackson in his 93, I think it was investigation rather than trial. Correct me if I'm wrong. I could Google it, can't be bothered. Michael Jackson in 93 on the Geordie Chandler allegations gave a talk on the television. I remember that as a 7-year old being one of the first memories I have vividly of the TV. Michael Jackson wearing a red shirt and talking about how he's innocent of the charges. However, I can't remember if that was after charges were brought or the case began. But as a general rule, individuals are not able to talk about the case upcoming. Now, here's the interesting thing. In terms of enforcement, and this might link to the Michael Jackson case, O.J. Simpson did nothing of the sort because nothing of the sort was available. Michael Jackson could only do it because he was so famous. In terms of enforcement, you will find that usually up until now, the courts don't normally pursue contempt of court charges or any other procedural charges against defendants who talk out a little bit on your social media. And I would say this is because the courts aren't aware of it. So what happens when a celebrity does? You see, the courts absolutely have the mechanisms to enforce contempt proceedings against either defendants or newspapers. And if a newspaper article is prejudicing the jury rather than just reporting the facts of charges, then that's very widely available. It will come to the attention of the CPS, to the court, and things can happen. But if Ronnie and Reggie from down the street, or Gotti from down the street, uploads an Instagram reel about their upcoming trial, the police, the CPS, the judge might not even know that that exists because we're all anonymous. My videos are getting about 50 views a video. So, for example, I'm not a defendant and I'm not on trial or anything, by the way. I'm a lawyer, not practicing. This is not legal advice. Better call Saul. But the serious point is, in the next 5, 10, 15, 20 years, when almost everybody, even individuals like me, private individuals, are posting their thoughts on social media, I'm sure there's going to come a reckoning whereby there is going to be a public education campaign or court enforcement to stop individuals talking about their cases, talking about the accused, and so forth. Finally, from a legal perspective, and again, not legal advice, this is just for information, just like not a fun talk, just an informal conversation between me and my subscribers. Interestingly, there is also the issue of defendants prejudicing themselves by talking too much, like I do. I'm not a defendant, I'm a lawyer. But individuals who talk too much prejudice themselves. There's a lot of intricate legal details here as to what subjudice, what speech counts as attempting to influence a trial or prejudice a case, and the enforcement of this. So, for example, if a celebrity, let's say, Mr. Gotti was on trial for shoplifting, and he did some YouTube videos on his past career of playing the piano, then that's got nothing to do with anything. That's fine. But then what if when he's talking at the piano he says, I always paid my tutors, I'm a very honest person? That goes to probity around honesty. Where's the line? I think overall the courts have not, as of yet, got to grips with this problem. And the generation younger than me, because I'm no spring chicken, are the online natives, always use the internet. So how will the courts comprehend and apprehend this phenomena in the decades to come? And as I'm currently living in Britain, I'm always very scared of posting anything online because you've got to be so careful what you say in this country nowadays. But luckily, I'm a lawyer and I'm very intelligent. I know words, I know all the best words. Critical criminologist out.